wishes to argue that paragraph 9 does not have retrospective application to costs incurred and payable before that paragraph came into force. It relies on the wording and purpose of the legislation and on the common law principle leaning against retrospectivity of legislation. But in addition, it wishes to argue that if, applying conventional principles of interpretation, paragraph 9 would otherwise have retrospective effect, the court should apply section 3 of the Human Rights Act 1998, and so as to avoid an unlawful interference with the landlord's possessions, contrary to Article 1 of Protocol 1 to the European Convention on Human Rights, A1P1. The Secretary of State objects to that point being taken. She argues that the point was not taken below, was not mentioned in the application for permission to appeal, and hence is not within the grant of permission to appeal, at least without amendment of the grounds of appeal, and would require, or at least entitle, the Secretary of State to adduce evidence relating to the legitimacy of the aim of paragraph 9 and its proportionality. Thus, she argues that the Court of Appeal should decide the question, applying conventional principles of interpretation, and should ignore section 3 of the Human Rights Act. The Upper Tribunal dealt with the question of retrospectivity at paragraphs 119 to 170. In the course of its discussion, the Upper Tribunal referred to the decision of this court in URS Corporation Limited and BDW Trading Limited, which concerned a different provision of the Act. The court in that case decided that section 135 of the Act did have retrospective effect. The Supreme Court has granted permission to appeal in that case, and the appeal is to be heard in December 2024. Lord Justice Coulson gave the leading judgment. He referred, amongst other cases, to the decision of the House of Lords in Wilson and First County Trust Limited No. 2, 2004, 1AC 816, about the need to construe any statute in a way that was compatible with convention rights. The Upper Tribunal in the present case took into account the general presumption against retrospectivity, but did not specifically address the effect of section 3. Leaving aside the procedural objection for the time being, it seems to me that if an argument under section 3 is raised, the court would ordinarily proceed in the following 8 stages. Interpret the legislation according to conventional principles of interpretation, including the common law presumption against retrospective legislation. 2. If the appeal succeeds on that basis, section 3 does not arise. 3. If the appeal would fail, but for the operation of section 3, consider whether that conclusion would be unlawful under A1P1. 4. In order to evaluate that question, the court would need to consider A, the legitimate aim of the legislation, and B, the proportionality of the legislative solution. 5. If there is no incompatibility, the appeal fails. 6. If there is incompatibility, consider whether section 3 permits a different interpretation. 7. If no, the appeal fails. If yes, the appeal succeeds. This is a slightly expanded version of the process described by Lord Justice Singh in R. Katie against the Secretary of State for the Home Department, 2022 QB 695 at 133. The Secretary of State's principal procedural objection is that there is no, or at least inadequate, material on which the court could answer the question raised at stage 4 of this process, and therefore that question should not be answered at all. There are, in my judgment, 3 principles in play. The first is that the Court of Appeal will not usually permit a new point to be taken on appeal if the point requires further evidence or fact-finding. The second is that the Court of Appeal will not generally receive evidence that was not before the lower court. The third is the imperative command in section 3 that so far as it is possible to do so, legislation must be read in a way that is compatible with convention rights. Section 6 of the Human Rights Act also prohibits a court from acting incompatibly with convention rights. The first of these principles was considered by this court in Notting Hill Finance Limited and Shake, 2019 4 WLR 146. Mr. Justice Snowden, sitting in this court, referred to a number of previous cases, and at paragraph 26 said this, quote, "These authorities show that there is no general rule that a case needs to be exceptional before a new point will be allowed to be taken on appeal. Whilst an appellate court will always be cautious for allowing a new point to be taken, the decision whether it is just to permit the new point will depend upon an analysis of all the relevant factors. These will include in particular the nature of the proceedings which have taken place in the lower court, the nature of the new point, and any prejudice that would be caused to the opposing party if the new point is allowed to be taken," unquote. There is therefore a spectrum of cases. There is also a spectrum of newness. See Crown on the application of Ario in Richmond, London Borough Council, 2024 EWCA Civ 960. In further submissions made to the Upper Tribunal on the 26th of October 2023, with reference to the URS case, the landlord referred expressly to the need to construe a statute compatibly with convention rights. The point was not developed any further, and Mr. Birdling accepts that this argument is a new one. But he says the point raised by the argument based on section 3 is in one sense not a new point. The underlying point is the same. Paragraph 9 should not be given retrospective effect. It is a different legal argument leading to the same result. Mr. Loveday for the leaseholders pointed out that the appellant had had a number of opportunities to raise the section 3 argument, but had not done so. That is a relevant consideration, but not in my judgment a weighty one. He also said that the leaseholders' legal team were working pro bono. That too is something to be borne in mind, although he advanced that submission principally in support of a submission that the appeal should be heard sooner rather than later. I will deal with the question of timetabling later on. The legislation in issue was not in force when the application was heard at first instance. The point arose for the first time on appeal to the Upper Tribunal. This removes it from one end of the spectrum to which Mr. Justice Snowden referred. On the other hand, although the interpretation of the legislation is a question of law, it is not a pure question of law in the sense that the court may have regard to a wider range of material, including evidence, which would not be admissible in a traditional exercise in interpretation. As Sir James Eadie KC submitted, one reason why an appeal court does not allow new points to be taken is that it does not have the benefit of the trial judge's findings of fact or the trial judge's evaluation. That is because an appeal court will only rarely interfere with the trial judge's conclusions on such matter. But where the issue is whether a rule, including primary legislation or policy, is compatible with convention rights, it has been said that the appeal court does not accord any deference to the first instance court's proportionality assessment, but carries out its own assessment. See Dalston Projects Limited and Secretary of State for Transport, 2024 1 WLR 3327 at 25 to 26. Nor is the determination of whether an interference with a convention right is proportionate an orthodox exercise in fact-finding. See In Re Abortion Services Safe Access Zones Northern Ireland Bill, 2023 AC 505 at 30. Moreover, this is not merely a case that concerns the particular facts of this case or these particular parties. What it raises is the interpretation of a public act of Parliament, which will have potentially wide implications. It is also true, as I have said, that an appeal court will not usually receive evidence that was not before the lower court. Most applications of this kind are decided in accordance with the principles in Ladd and Marshall. In addition, most such applications are opposed. Here, the landlord is willing to permit the Secretary of State to adduce evidence or other material if she wishes to do so. In White and First County, Lord Nichols addressed the question of how the court should go about deciding whether a particular interpretation of legislation would be incompatible with convention rights. He said at paragraphs 62 to 65, which I won't read out, but please transcriber put them into the transcript, Lord Hobhouse agreed and said at 142, Quote, the questions of justification and proportionality involve a sociological assessment, an assessment of what are the needs of society. This in part involves a legal examination of the content and legal effect of the relevant provision, but it also involves consideration of what is the mischief, social evil, danger, etc., which it is designed to deal with. Often these matters may already be within the knowledge of the court, but equally there will almost always be other evidentially valuable material which can be placed before the court which is relevant, such as reports that have been made, statistics that have been collected, and so on. Oral witnesses may have important evidence to give. To exclude such evidential material from the case merely because it is found in some statement made in Parliament is clearly wrong, particularly if ministerial statements made outside Parliament were already being relied on, unquote. But there are nevertheless many cases in which the court has decided whether to apply Section 3 on the basis of argument rather than evidence from the relevant government department. I would not therefore subscribe to the view that evidence is indispensable before the court makes a decision. In addition, there are cases in which the question of incompatibility is raised for the first time at appellate level. Wilson and First County itself is one such example. In that case, the Court of Appeal had to consider the enforceability of an agreement under the Consumer Credit Act. At the first hearing of the appeal, only the lender and the borrower were represented. Neither party relied on the Human Rights Act. Nevertheless, the Court of Appeal decided that it was arguable that provisions of the Consumer Credit Act might infringe the lender's convention rights, and directed a further hearing to which the Secretary of State was to be a party. The Secretary of State duly appeared at the resumed hearing and made submissions. Although the House of Lords reversed the decision of the Court of Appeal on a substantive point of law, there was no criticism of the procedure that the Court of Appeal had adopted. As Lord Wolfe said in Popular Housing Association and Donoghue, 2002 QB 48 at 30, the Court of Appeal must be flexible in its procedures when a point arises under the Human Rights Act. Indeed, the Supreme Court took a similar course in Lawrence and Fenn Tigers No. 2, 2015 AC 106, where a point was raised in the Supreme Court about the compatibility of a costs order with Article 6 of the Convention. Likewise in Poplar Housing, where the question was whether a mandatory ground for possession infringed Article 8 of the Convention, this court permitted the parties to adduce further evidence after the hearing of the appeal. That included witness statements on behalf of the relevant government department, evidence from shelter, and from academics. I would accept, therefore, that the Secretary of State is entitled, but not required, to adduce evidence on the question of compatibility with Convention rights. In the absence of evidence, the court will form its own evaluation, as it did, for example, in Wilson and First County. As Lord Wolfe said in Poplar Housing at 61, it is not necessary to hold a state trial into successive governments' housing policies in order to balance the public and private issues to which Article 8 gives rise. Nevertheless, in that case, the court did evaluate the evidence adduced before it on the question of incompatibility, even though none of that evidence had been before the lower court. The third principle is that the court must interpret legislation in a way that is compatible with convention rights. Lord Wolfe said in Poplar Housing that Section 3 is mandatory in its terms. And Lord Hobhouse said in Wilson at 131, the duty under Section 3 is the same in both the original trial court and any appeal court. This court made much the same point in Bewlale and the Secretary of State for the Home Department, 2009 QB 536, where a point arose on certain immigration regulations for the first time in the Court of Appeal. There is also the question of precedent to be considered. If, without regard to Section 3, this court decides the section means X, to what extent is a subsequent court free to decide that in the light of Section 3 means Y? Short of any appeal to the Supreme Court, the decision of this court binds both lower courts and this court itself, unless it can be said to have been decided per incuriam, or falls within one of the other exceptions in Young and Bristol aeroplanes. The decision of this court is not decided per incuriam merely because, with the benefit of different or better arguments, it would or might have decided the case differently. Could it be said that this court decided the case in ignorance or forgetfulness of some inconsistent statutory provision, which is another of the exceptions? In circumstances in which the court was fully aware of Section 3 but declined to apply it, that seems to me to be very doubtful. But even if another court or tribunal could decline to follow our decision, unless and until it did so, the law would be left in a state of uncertainty. And it is clear from the reasons that the Upper Tribunal gave for the grant of permission to appeal, its expectation was that, subject to any appeal to the Supreme Court, this court would provide a definitive answer. Weighing all these factors together, I consider that the landlord should be entitled to advance the argument based on Section 3 of the Human Rights Act, but that the Secretary of State should be entitled to adduce evidence on the question of compatibility if she wishes to. That brings me on to the question of timetabling. Mr. Allison has proposed a timetable which seeks to bring the parties before the court by the end of the Michaelmas term or early in the Hillary term 2025, that is to say December or January. Sir James objects cogently, in my judgment, that that does not give the Secretary of State sufficient time. This is not wholly analogous to a judicial review claim, where a number of discrete procedural steps would have to be gone through before the defendant is required to put in evidence. I agree with him that the Secretary of State should have 6 weeks to put in whatever evidence she sees fit. I also agree with him that that means that the December hereby date is too tight a timetable. Rather than fix a date in January, I propose to direct that the appeal be listed by the end of the Hillary term 2025, that is before Easter 2025, which is going to be in mid-April. At the moment, the Adriatic appeal is linked with another appeal, the Triathlon appeal, which also raises questions about the Building Safety Act. The Triathlon appeal has a hereby date of May 2025. There is some overlap between the two appeals, although there are many points of difference. Two of the parties to the Triathlon appeal wish to maintain. The management company in particular is very concerned to know whether it can safely let contracts for remedying building safety defects. It must not be forgotten that until such time as remediation works are carried out, there are thousands of people living in potentially unsafe flats. The third party to that appeal, SVDP, the developer of the estate, wishes to maintain the hereby date of May 2025, and if necessary for that purpose, to decouple the two appeals. The only reason of substance put forward by Miss Crampin was that her leader, Mr. Jonathan Selby, KC, was at present due to be engaged in 2 long trials, which would not finish until the middle of April 2025. The weight that I can give to what is in effect counsel's convenience is necessarily dependent on the type of case involved, the degree of specialist expertise required, the length of time before an altered hearing date. This is not, in my view, a case in which there is a need for further fact-finding in the conventional sense. It is a question of statutory construction. Cases booked often settle, and there is ample time to instruct alternative counsel if need be. I do not consider, therefore, that counsel's convenience can outweigh the desirability of a relatively speedy answer to the questions raised by the appeals, all the more so since until such time as answers are given, thousands of people are living in what are potentially unsafe flats. I will direct, therefore, that the 2 appeals will be heard sequentially by the same constitution, and that they are to be listed for hearing by the end of the Hillary term 2025. I will expect all parties to cooperate in agreeing a detailed timetable for the adduction of evidence necessary to deal with the Section 3 argument and the lodging of skeleton arguments. If there are any disputes about the timetabling, they can be decided by a master or on the papers.
Thank you, Michael. I don't think any matters arise from your Lordship's judgment. We'll put our heads together and agree in order.
Thank you very much.
May I just rise and I don't think you indicated which case was to go first, which was
I think I would expect you to sort that out between you all.
Parties cannot agree at the moment.
They can't agree.
We have tried, but there is a difference between one of the triathlon parties who is insistent they should go first and the other parties who are either neutral or say Hippersley should go first.
Why does it matter? They're going to be heard sequentially by the same constitution. Why does it matter?
Well, firstly, for the reasons I said earlier, there may be a question of what is more convenient for this court in terms of whatever. The point I made earlier was with the A1P1 argument, you're going to have the evidence from the Secretary of State on that, and potentially from us. As to, and the evidence from Secretary of State will be to justify the legislation in Part 5 in particular. So that's why I say Hippersley makes sense to go first before you're construing the same bit of legislation in the context of the triathlon appeal. So that's a question of whether it would assist the court to have it in a particular order. I don't know, it's for Mr. Letman to explain why he says he should go first. But equally, I suspect it will also make a difference to whether the parties are seeking to make written submissions on the other parties' appeals, whether they be kept separate, which again is a matter that's...
Right. Mr. Letman, why does it matter?
Lord, the order in which they're heard is not a matter that we will go to the barricades over. I think in the light of the decision on A1P1, it may make sense for the Hippersley appeal to go first.
For the which one?
The Hippersley appeal to...
That's what I've called Adriatic.
But yes, the Adriatic appeal. But then again, depending on the availability of counsel, for example, if for any reason the leaders in Adriatic were not available, it may make sense for the East Village appeal, the triathlon appeal, to go first. So I'm quite content for it to be
I think
left.
the Adriatic appeal should go first. If there is some particular difficulty that arises, then any party can apply to change the order of events.
So,
All rise and able.